Court of Appeal under the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons having business before the court draw near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Looks like we have a lot of nice ambiance there in the back of the room. We'll let you know we came in through a hall that had no light, so thankfully we've got a veteran crew here and somebody found the light switch. So as our marshal announced, I'm Chief Judge Edwards. I'm presiding. To my right is Judge Rand Wallace. To my left is Judge John McIver. We have one case this morning on this docket. And that's Discount Tire Company versus Tammy Bradford as personal representative of the estate of Michael Bradford. It's case 22-1901. Typically what we do is reserve 5 minutes for rebuttal. If you want a different time, let us know. The time on the clock is the total time. Every now and then somebody asks that question. It's not, you don't get 5 more minutes after that or whatever. That's your total time. You'll see a nice bright yellow light pop up when you're into your rebuttal time. If you don't notice it, I may point it out to you. If you have noisemakers, I'm talking about lawyers, parties, everybody else, please put it on mute or turn it off because it's bound to go off right exactly at the wrong time. And before we actually get started, I would just ask counsel and all those out in TV land, please make sure when you're citing to the record, you really go back and double check that. We had a couple of points where you're going to look at the really key testimony and instead it's like an index of a transcript page or something. And likewise, if you're going to cite to somebody's testimony, please go back to the trial transcript to do that. Don't cite to your motion or a response to the motion where you're saying, here's what Johnny Jump Up said about ABC. Because we really do read, and this transcript, well, the transcript wasn't that large. The record was huge. The transcript wasn't that large, obviously, with the DV. But anyhow, that would be my request of everybody present, and like I said, both of the people watching it on YouTube. And with that, we will commence.
Good morning. Please the court. My name is Lauren Purdy with the law firm of Gunster, Yoakley, and Stewart. With me at council table is my law partner, Ken Bell, and together we represent Discount Tire. The issue in this appeal is whether Discount Tire's failure to follow its internal policy that Appley's expert testified was one step higher than the industry standard was sufficient to establish a triable issue on the breach of the applicable standard of care. The trial court's order granting a new trial was based solely on its reading of Moyer versus Reynolds, and it should be reversed for 3 reasons. First, the trial court's incorrect reading of Moyer is the narrow issue on appeal. Rule 1.530F states very unambiguously that an order granting new trial must state the specific grounds therefor. And the scope of this court's review is limited to the specific grounds contained within the 4 corners of that court's order. And courts around the state of Florida have reiterated this concept over and over again. Plaintiff may raise multiple grounds in a motion for new trial, and only one ground is addressed in the order on appeal, and only that ground is at issue in the appeal. So the Archer-Daniels case, Hutchinson, Jones versus Atkins, State Farm versus Gage, a undisputed point of law. Now the order on appeal in this case is laid out in full at our reply brief at page 1. It's also located in the record at 7345. And it states, based on this court's reading of Moyer versus Reynolds and its acceptance of plaintiff's argument that Moyer stands for the proposition that evidence a defendant failed to comply with its own internal policy or procedure, and then continuing, is therefore sufficient to defeat a motion for directed verdict based on insufficient evidence of a breach of the standard of care. Now, that is a pure question of law, and a pure question of law, which the appellees concede at page 25 of their answer brief, a pure question of law is subject to de novo review, not a more deferential abuse of discretion standard of review. And that is the applicable standard for this court in evaluating the trial court's order, evaluating its application of Moyer in this case. Now, it's apparent that that's what the trial court was doing based on the arguments that the appellees raised in their motion for new trial. At their reply brief at page 4, we go through this, in our reply brief, and it's also in the record at 7-1-34-35. Discount Tire's motion for directed verdict should have been denied because there was evidence it violated its own policies regarding tires that are 10 years old. That's its motion, their motion for new trial. And they state the disjunctive is important. It can be established by violating your own policy or the industry standard. So that is what's at issue. That is the only point of law that's at issue here. And going to our second point, the failure to follow an internal policy alone is not sufficient under Florida law to establish a violation of the standard of care. And I think we know that that's true because the appellees don't even argue that in their answer brief. Clearly argued it before the trial court, invited the trial court to error, and do not argue in their answer brief that a violation of an internal policy alone is sufficient to establish by itself a violation of the standard of care. They don't even attempt to cite or argue any cases that we cited in our initial brief. All they say is, well, the order on appeal doesn't specifically say that as a matter of law, a violation of internal policy alone is sufficient. But when you read the order in context, particularly the part where the order says, and therefore is sufficient to defeat a motion for directed verdict, it's clear that the trial court was concluding under Moyer that a violation of an internal policy alone is sufficient for the issue to get to the jury. And
Let me ask you this. On this appeal, do we have any business considering whether or not the directed verdict was properly granted?
No, Your Honor, because under Rule 1.530F, the scope of the review is limited to the issues in the order that is on appeal, and only the issues in the order on appeal. And the appellees raised many other issues in their motion for new trial. The only issue the court accepted and the only issue that's addressed in the order is the application of Moyer versus Reynolds. And again, Moyer and the many cases we cited in our brief repeatedly recognize that an internal policy alone isn't sufficient. The Moyer case is only about the admissibility of a policy when it is relevant. And we would concede that a policy can be admitted into evidence in connection with a trial, but it's not sufficient itself to create a triable issue just because a company violates an internal policy. And the Walmart versus Whitkey case goes through this in detail. In that case, the trial court's order was reversed because it issued an instruction that violating the internal policy alone was negligence. The Mayo versus Publix case, the Dominguez versus Publix case, both reiterate this point throughout Florida law that an internal policy does not itself fix the standard of care. And that makes sense. We don't want, as we discussed in our initial brief, a race to the bottom. Companies and people should be incentivized to go one step higher, which is exactly what Appley's own standard of care experts said Discount Tire's policy was in this case. Now, third, again, just sort of reiterating this point of what was actually argued, what was actually presented in terms of testimony, Appley's standard of care expert, who was all over the place at points in time, but ultimately testified Discount Tire's policy was one step higher. And if it's helpful to the court, Mr. Zembauer's testimony is located between 7839 and 7939 of the record. And in his direct, he does admittedly, as they say in their answer brief, state that Discount Tire's policy was consistent with the industry standards, and their policy was to remove the tires. That's at 7903 of the record. But on cross-examination, Mr. Zembauer admitted that wasn't the policy at all. It wasn't their policy to remove the tires. Their policy was to refuse service. That's at 7182 of the record. And he also admitted that only Discount Tire and Zembauer Auto, a auto shop of one store that he owned, the only places that even have that policy.
And all the private confidential ones that he couldn't mention, right?
And all the private confidential ones that he could not mention, that he did not identify for the jury. And he ultimately testified that the industry standard just requires recommending replacement. That's what he testified. Now, the interesting, kind of confusing thing in this appeal is in the directed verdict, in their motion for new trial, and on appeal, the appellees do not say that that is the standard of care. They say the standard of care was to remove the tires. In the directed verdict hearing, they said seize the tires, even though Mr. Zembauer didn't even testify to that point. No one testified that the tires should be seized, which the trial judge recognized in the hearing on the directed verdict motion. In their motion for new trial, they tweaked it a little bit and they said remove the tires or refuse service. That's the standard. They should have, well, the problem was that they rotated the bad tires to the front and put 2 new tires on the back. Well, Mr. Zembauer didn't testify one word about rotating tires. And again, he testified refusing service was 1 step above the standard of care. So there was no testimony about whether or how a tire retailer should remove tires if the customer will not let them, commit conversion, I guess. There was no testimony that the standard of care required a tire retailer to then refuse service if they first attempted to remove them. And there was no testimony about negligence in rotating the old tires and putting new ones on the back. In fact, just the opposite, the only testimony from the trial from Discount Tires employees, which is located at 7244 of the record, was that their policy was to put the newer, better tread tires on the back because that's safer. If you're not going to replace all 4, you put the tires with the better tread on the back. And that's exactly what they did here. So ultimately, all of the evidence that was presented in connection with the plaintiff's case in chief was Discount Tire's policy actually was 1 step above the standard of care. They didn't rehabilitate that testimony on redirect, and the appellees haven't argued in their answer brief that they had no obligation to redirect. They've waived that argument here before this court. Otherwise, the only other testimony from the expert was something about removing tires, but there was no testimony about who should do that, and that was tied to a manufacturer's recommendation of when tires should be taken out of service. So even the very standard that he purported to rely on did not say you have to remove the tires.
Was part of the standard to document the Department of Transportation number on each of the tires?
We would argue no, Judge Wallace. We actually think that there's an interesting additional issue that's not really before this court, which is whether there was really a standard of care or some duty and what that duty looks like. There was no evidence presented that there is some broad custom or practice that requires tire retailers when a customer comes in to a store on when they should recommend replacing or how they should do that or what the context should be. All there was Mr. Zembauer's testimony about what 2 tire retailers in the entire country do. So I know that's not exactly answering your question, but we don't even necessarily concede that there was a standard that was violated. But the DOT numbers is just another part of an internal policy that Discount Tire has. And there's no regulation that requires that. There was no testimony presented that that is a broad, pervasive practice that all tire retailers do. So we would argue that it's not.
It sounds to me like there was a pretty big swing of, a factual dispute as far as the age of the tires, but yet there was never any hard evidence about exactly, what was the batch, the lot, the number of the tires. I mean, you've got anywhere from a 6 to a set of 14-year-old tires. That's a pretty big swing, and yet in the evidence, it was never borne out that there was any firm logging of the age of the tires by Discount Tire. To me, that seems kind of a little concerning.
Judge, that may be true. The evidence was a little mixed, right? And we only have the plaintiff's case and their view of the world. But the more important point, I think, is regardless of whether Discount Tire did or did not strictly follow its policy, following the policy by itself is not itself sufficient evidence of a violation of the standard of care. And that is all that they were ultimately able to present to the trial court to get an order granting a new trial based on
Anybody move for rehearing on the motion granting a new trial?
No. There was no motion for rehearing. The appellees never sought additional findings of fact relating to the other arguments that they raised that were rejected implicitly based on the text of the court's order, ruling solely based on the Moyer versus Reynolds decision. So that is what this court is confined to, and it's clear based on their own arguments in their answer brief that that was an error of law that they led the court to. And for that reason, this court should reverse the order granting a new trial and find that in the state of Florida, violating an internal policy alone is not sufficient to get to the jury on a violation of a standard of care. If there are no more questions, I'll reserve the rest of my time.
All right, thank you.
Thank you.
Good morning.
Morning.
May it please the court, my name is Chris Carlisle. I represent, Ms. Bradford, the appellee. Your Honors, based on what we just heard, there's a lot of that I agree with, which should not be surprising, and there's also a lot that I disagree with, which also shouldn't be surprising. We agree.
Didn't expect you to give up, so.
We agree that this court is limited to a review of the face of the order that was entered here. And counsel did not read the entirety of the order, but reading the face of the order indicates that it does not say what they're suggesting. It says the order does not say that the evidence of your own internal, a violation of your own internal policies alone, which is the word they use over and over in their briefs, is sufficient. The order actually tracks the language of Moyer. If we read the order, it says, and again, I would invite the court to read along with Moyer. Evidence a defendant failed to comply with its own internal rule or procedure is evidence of the standard of care and evidence of a breach of the standard of care, and is therefore sufficient to defeat a motion for directed verdict. Counsel left out the critical part of that, which tracks the language of Moyer. Nothing on the face of this order stands for the proposition that alone of a breach of your own internal policy establishes the standard of care. That's not what the court said. Now, acknowledging that there were essentially alternative arguments made in the motion for new trial, it was urged that Moyer stands for that proposition, and we heard an argument that we have abandoned that argument, but the question is this: why would we make the argument when the order didn't accept that argument? We are stuck with, according to their own position, which is true, the face of the order, and nothing in that order does anything besides say Moyer says that it's evidence of the standard of care, which is precisely what was done in this case. If you look at their own brief at page 1, they acknowledge that the motion for new trial did more than just argue that their violation of their own policy established and breached the standard of care. They state, appellee argued in the motion for new trial that it produced evidence of the applicable standard of care through expert testimony, industry standards, and Discount Tire's internal policy. Even if the motion for new trial did what they suggested did and argued that alone a violation of your policy was enough, the court rejected that. But that's not what the motion for new trial did. It said, here is all the evidence that Zembauer brought forward here. And the trial court, after reviewing the evidence, and again, I would suggest if you read the transcript,
of all of that evidence, what was the only piece of evidence that Discount had allegedly violated?
Zembauer testified that their policies were consistent with the industry standards. And again, there is essentially sort of a confusion, and again, I wish that all trials were perfect.
You were saying that there was more than just
A violation of their
internal policy alone, that there were also these other factors that could be evidence of a standard of care.
Yes.
What other factors did Discount allegedly violate besides their internal policy?
Zembauer testified that the industry standard on various tire manufacturers were that it was undeniable that after 10 years, they urged that they be removed after 10 years. Everyone acknowledges they're not safe after 10 years. That is
Counsel,
why.
we're talking about, and I don't want to step on his question too much, I
Your
want you to
Honor.
answer it, but we're talking about a tire retailer, not a tire manufacturer.
Correct.
And
And the
Mr.
tire-
Zembauer focused on manufacturing.
He used the
practices.
manufacturer's recommendations to establish the standard of care for tire retailers and says that's reasonable. I think everyone perhaps has had a flat tire and gone to a tire store and they say, we can't fix that, it's on the tread. It's not on the tread, it's on the side. We're not going to do this. There's a standard of care that is present there, and he used the industry standards to establish that for the retailers. And the retailer even
You're
has
talking
their
again
own.
about, you're talking about servicing a tire, I guess, when you're talking about patching a flat, which I guess
Which
no
is
longer
exactly
you
what
patch
happened.
anything, you plug them, but whatever.
Yes, Your Honor.
And Zembauer, on servicing a tire or refusing to service a tire, said it was his store and Discount Tire, in terms of evidence he could present to the jury, that their standard was to refuse to service, correct?
Zembauer said a lot of things,
know
and that
he
was,
did.
again, but I think, again, it's important, and Judge Wallace, I believe, or maybe you did, Judge Edwards, asked a question about the directed verdict context here. This is, again, a directed verdict that was granted, and then the trial court realized I shouldn't have done that. What are the standards for a directed verdict? The totality of the evidence, any evidence here. So we can go through, and Zembauer, like most witnesses who testify extensively at a trial, maybe said some things that were a little bit all over the board, but did he provide evidence and did he testify that the standard of care and the industry standard was violated here? Yes, he did, over and over and over. He said, then he talked about Discount Tire.
Judge McIver's question, what other evidence was there other than they violated their own standards?
Again, Zembauer testifies that the policies and procedures are consistent with industry standards. He testifies that, again, everybody in the industry recognizes that 10-year-old tires are unsafe, which is why they have that policy. He testified, even when he was asked on cross-examination about this, that about whether the industry standard of care was to refuse service. It's not uncommon, but it does follow the tire manufacturer's recommendation that tires should come out of service at 10 years. Testified it would not be wise to perform service on 10-year-old tires because now you're violating the standards that's developed by the manufacturers themselves. And his own testimony throughout was that the standard of care was violated. He was using the industry standards to establish the standard of care. He was an expert who could do that. And again, think about what happened here. If we all recognize that 14-year-old tires are inherently dangerous and they have their own policy to do that, their position is all we had to do was say, we're going to recommend you buy some new tires. I don't want to do that. Okay, we'll take those dangerous tires and put them on the front. Zembauer is saying that violates the standard of care in the retail tire industry. He was allowed to testify about that. He did testify about that. And for them, for the other side to suggest that somehow all of that testimony should be thrown away, and we're going to nitpick a piece of evidence here and there where he maybe said something slightly contradictory, ignores the reality of a directed verdict in which all inferences have to be done or resolved in our favor.
But we're here not on the directed verdict. If we were, those arguments make a lot more sense to me. We're here on the new trial order, and you accurately read the new trial order, and we've all read the new trial order, and I guess people can disagree on exactly what they take away from it, but the judge didn't go, you know, I overlooked this testimony and that testimony and the other testimony. The judge goes, you know what, Moyer says, you get by a directed verdict with this evidence of that, of the violation of your own internal standard, but yet Moyer itself says that it's merely some evidence of the standard of care, and its admission must be qualified by a cautionary instruction to the jury that the evidence by itself does not establish a standard of care. And again, here, what seems to have happened is not whether it was a recommendation or not, but whether they serviced the tire by rotating it, by keeping it on the car. Plaintiff's counsel, in arguing to the lower court, said, in response to a question from the judge, are you saying the tire retailer should have seized the tires? And the answer was absolutely. And I don't know how you take it out of service unless you seize it. And nobody, including Zimbauer, and the trial judge noted this, nobody said the tire retailer has a right to take somebody's tires from them.
I agree with that, Your Honor. And again, I would suggest that as a source of confusion with the trial court, and also, again, it was essentially a red herring. Obviously, you're not seizing tires. What can you do? You can refuse service. You can say, I'm not going to take these. What if someone comes in with the tread hanging off? I'm going to say, fine, yeah, I'll put them up on the front, as long as I'm kind of suggesting maybe you should
Tire's
not
not
do this.
14,000 miles further. This is not a piece of tread hanging off. I mean, I understand probably better than most about tires because of my past history, but.
Okay. Let's look at, you said the absolutely comment there. What does he say immediately after that? They should have told him they are not putting this tire on the front, or they should not have put the tire on the front because that is a violation of industry standard. Industry standard says you take a tire out of service, not you take a tire from the rear and put it on the front. So again,
that goes to the service aspect. And Zimbauer's testimony, although it was all over the place on that particular point, really couldn't have been a whole lot clearer. And he said it probably a little grudgingly, but he admitted that taking the tire out of service or refusing to service the tire, however you want to put it, was not the industry standard. He said it may be not uncommon, it's consistent with the manufacturer, but he says that's not the industry standard.
He said it was
that's where we are.
He said it was consistent with the industry standard. He testified over and over.
But he said when asked that specific question, and I've got it here, but when asked that specific question for the second or third or fourth time, whatever it was, he finally says it is not the industry standard.
Your Honor, again, the totality of his testimony, again, indicates, is that policy consistent with the industry standard at a different portion of his testimony? He says, this is at 78, 69, 70, it is. Most all tire manufacturers, vehicle manufacturers, have recommendations on when to take a tire out of service, ranging from 6 to 10 years. So whether or not
that's
it
a
says...
tire manufacturer, that's evidence of what the tire manufacturer ought to recommend. So if you're suing the tire manufacturer and they didn't say at the proper time frame with the proper age of tire, you should take this out of service, that's one thing. But the vehicle manufacturer, we know that's another thing. You know, the Ford Explorer Firestone cases, we know all about those. But I'm looking at page 7911 of the record. And the question is, just trying to see if you'll answer this question directly, Mr. Zimbauer, because it is really a simple question. Is it the industry standard of care to refuse service at 10 years, yes or no? And going over to 7912.
And I think that it's made clear is that the industry standard was that 10-year-old tires are dangerous. You don't service them, you suggest you replace them. There's a lot of stuff that's going on there, and he testified that their policy, and again, we're not suggesting that not manufacturers, but servicers should not have a stringent policy in place. It's consistent with that. Their policy is, we're not going to service these things. Does everybody in the industry say that? No, but everybody in the industry recognizes that something should be done when tires are 10 years or older. And that was the totality of his testimony. And again, this could all have been argued to a jury. And I agree with you that obviously we're talking about the order and the face of the order in the context of a motion for new trial, but it is an unusual circumstance that the motion for new trial was granted recognizing that the standards for directed verdict were not met. And the trial court, with the review of all of this testimony, comes out and says, Moyer doesn't say that violation of your standard alone is. Moyer says it's evidence of this. Again, the court at that point had the trial transcript, had all of this argument in front of it, and says, quite appropriately, I think I made a mistake. This should have gone to the jury. There was ample evidence in this record through Zembauer, although again, it could have been clearer, it wasn't, but it was there. And I shouldn't have granted a directed verdict because there was enough that he presented here.
You
And
had
to
the
suggest-
opportunity to clarify any ambiguity by filing a motion for rehearing. Realize it was your motion for new trial that was granted, but if you had concern with regard to the clarity of the order granting the new trial, you could have filed a motion for rehearing, correct?
Absolutely, but there is no concern about it because the order doesn't say violation of an internal policy alone establishes the standard of care. It says, Moyer says, it's evidence of the standard of care, which that's what the order says. It doesn't say that alone word that you keep hearing from the other side in argument and also in their briefs. The order is an accurate statement of the law, and so let's talk about the standard of review. They're arguing it's an inaccurate statement of the law. It's not. And so if it's not an inaccurate statement of the law, then this isn't a discretionary decision to grant the new trial, and you cannot say the trial court abused its discretion applying the law properly and recognizing that Zembauer testified extensively that the standard of care was violated in this case. I'd like to also raise one other interesting point that kind of has been somewhat overlooked so far. In their initial brief, they argued that there is no doubt that he gave these warnings, that he met the industry standard by suggesting that you should replace your tires. There was doubt about that. He didn't remember the conversation. He did not record the DOT numbers. There is entirely a possibility that even if the standard of review, the standard of care is what they suggested is, that a jury could have concluded it wasn't met because the evidence was conflicting. It was not absolutely unequivocal. Could a jury say, I don't know if this guy did it or not. He didn't even write the number down. He might not have even known how old these tires were.
Sealer's testimony was not the Rock of Gibraltar by any means.
Well, again, on a directed verdict, which is where we are essentially in the new trial.
That's what my question to you is, if we were here on a directed verdict appeal, but we're not. We're here on granting a new trial. If the judge had said, thinking back on it, they didn't really establish that they made that recommendation, then I think you're in a whole different ballpark. But reading this order, it's hard to think about anything other than violation of their own standard. I understand what you're saying.
Right.
You don't need to repeat it. I get what you're saying, and I understand from your brief.
Again, Your Honor, if this order contained an error of law, we'd be in a different position. It does not. It says the same language that was done by Murphy. What was argued in the motion, I think, again, we're hearing sort of a contradictory argument also in that you're only allowed to look at the face of the order. But they then argue, well, the face of the order must mean the same based on what they argued in their motion, which, again, we would point out the motion argued alternatively. So lots going on in this case, and there's a lot of interesting things that arise. Yes, the face of the order is absolutely critical for the court to look at and recognize. It does not clearly and unambiguously state a misstatement of the law as they suggest. Number two, even though it was the motion for new trial, it was granted based on a grant of a directed verdict. So it is relevant, and the trial court, with the benefit of looking at this, says, okay, there is enough evidence, I would suggest that's what the court was coming to the conclusion, that the standard was violated. It should have gone to a jury. I can't say there's no evidence that was brought forth below. I can't pick and choose portions of Zembauer that contradict other things and say, that's it. He testified about a lot of things concerning the standard of care. And again, to suggest that in this case, a directed verdict was appropriate, given Zembauer's testimony, given the fact that tires were 14 years old, given the fact that their own internal policy did this, given the fact that everybody in this industry knows those tires were dangerous, they think it's perfectly fine to take them on the back and put them on the front. It's not. And the jury should have been able to hear from Zembauer about this, cross-examine him, argue in closing all you want. But the court recognized I should not have granted a directed verdict. The court issued an order granting a new trial that is not a violation of the law, that completely tracks exactly what Moyer said, that the order is correct and not a misstatement of the law. Then this entire motion for new trial is reviewed under an abuse of discretion standard. So the big question is, and I think if we all come back around to this, what does that order say? And I think if the court reads it and looks at Moyer, it reflects Moyer, it's accurate, it's an accurate statement of the law, and if that's the case, it's not de novo review, it's an abuse of discretion, and can we say that the trial court, having the benefit of reviewing the trial transcript and all of Zembauer's testimony, says, I shouldn't have granted a directed verdict? That's what this case is about. Thank you very much, Your Honor.
Thank you.
Just want to reiterate a few points, and then if the panel has any other questions. First, I think it's important, Mr. Carlisle agrees that the review of this court is limited to the order on its face. Keeps talking about directed verdict, but admits the review is limited to the order on its face. Now, the suggestion that the order means something other than what we've discussed Moyer standing for is just not, I think, a correct reading of the plain language of the order. I won't read the whole thing again. I know the court has it, but the order says, based on this court's reading of Moyer and its own internal rule or procedure, and skipping ahead, is therefore sufficient to defeat a motion for directed verdict based on an argument that the plaintiff failed to offer evidence sufficient to establish the standard of care. So that order is consistent with a more summarized characterization, which is alone. That's what it means. So I think that's the first point. I wanted to very briefly correct a couple and raise a couple points that Appley raised in their argument, which is this idea about recommending replacement. And, well, maybe there's some question about whether they really recommended replacement. The more important point is they didn't argue in the directed verdict that recommending replacement was the standard. So even if we were on a directed verdict, that isn't what they argued the standard was. That is specifically not what they argued. They said the standard was seize the tires. In their motion for new trial, they did not argue the standard was recommending replacement of the tires. They didn't argue in their answer brief that the standard was replacing or was recommending replacement of the tires, and they couldn't because their entire case, which they reiterated in the record at 2869 to 70 in their motion in limine to exclude a discount tire warnings expert, their second and amended complaint, which dropped a failure to warn allegations. The second amended complaint starts at 2494 of the record. And in response to a motion to exclude Mr. Zembauer's testimony, Mr. Zembauer, they stated specifically, Mr. Zembauer is not testifying about warnings or giving a warnings opinion. And that begins at the record at 4361. So recommending replacement isn't what they have ever said the standard is. It's not what they say the standard is now. It's not what their expert was retained to opine about, and it is explicitly a claim, a cause of action that they have not asserted and that they did not argue on appeal. And the only last point I would make to reiterate is there was a suggestion that Mr. Zembauer did not say that recommending replacement is enough. Mr. Zembauer, as Judge Edwards pointed out in the record at 7911, specifically conceded recommending replacement is all that's required. So if there are no more questions for the panel, we would ask this court to reverse the order granting a new trial and reinstate the directed verdict in favor of discount tire.
Further questions? All right, thank you
Thank
very
you.
much. Well briefed and well argued. And we will be in recess.
Thanks.